Foreign capital is the lifeblood of globalized trade, but allowing outside entities to operate within sovereign borders carries immense risk. To protect the domestic economy, the state builds a strict legal perimeter. Today, we are conducting a forensic audit of Title 15 of the Revised Corporation Code. We will track the exact statutory life cycle of a foreign corporation from its initial entry to its eventual exit or execution. Section 140 uses the incorporation test, ignoring stockholder passports. If formed under foreign laws, it's a foreign corporation, but entry requires strict reciprocity. Their laws must allow Filipinos to do business there, or our gates remain locked. We must draw a sharp line between doing business and conducting an isolated transaction. A single isolated contract does not require an SEC license. A license is only triggered when the entity demonstrates an intent to continuously engage in commercial operations. For entities that have operated locally for decades, Section 141 acts as a grandfather clause, applying the principle of non-retroactivity. If a foreign corporation already secured its license under the old Batas Pambansa 68, that authority seamlessly continues under the new revised Corporation Code. State jurisdiction is strictly territorial. Bringing an extraterritorial entity under Philippine control requires a highly fortified border screening process to guarantee compliance before they ever reach the domestic market. This screening process begins with Section 142. A foreign applicant must expose its corporate DNA, submitting its articles of incorporation, its bylaws, and hard proof that it is solvent and in sound financial condition. These documents must be officially translated into an official language of the Philippines. If they remain in a foreign language, the application is legally void. For heavily regulated industries, there is a special clearance exception. Foreign banks and insurers cannot submit directly to the SEC. They must first pass through the Bangko Sentral ng Pilipinas or the Insurance Commission for approval. Once the SEC accepts the documentation and any required endorsements, it issues the license under Section 143. This is the exact moment the foreign corporation gains the legal authority to transact business. But obtaining the license triggers a strict timeline. Within 60 days after the issuance of the license, the foreign corporation must deposit acceptable securities with the SEC. This makes the deposit a condition subsequent. Failing to provide the securities does not prevent the initial licensure, but it triggers an immediate administrative suspension if the deadline is missed. The only exceptions to this specific SEC deposit rule are foreign banking and insurance corporations, whose reserve requirements are managed by their own primary regulators. For everyone else, this deposit acts as the state's financial anchor. The SEC physically holds these securities hostage to guarantee the protection of future domestic creditors if the foreign entity defaults. A financial anchor secures the money, but the state also needs a physical anchor for legal accountability. Section 144 requires every foreign corporation to appoint a resident agent. This agent can be an individual, provided they are a Philippine resident with good moral character. Alternatively, the agent can be a juridical entity, but it must be a strictly domestic corporation in sound financial standing. The core function of this agent is to absorb legal impact, receiving summons on behalf of the foreign entity. If the agent resigns, dies, or flees, the system has a fail-safe. Service of summons automatically reroutes to the SEC itself. By stipulating that service on the SEC is legally binding on the Home Office, the state ensures that domestic plaintiffs can secure valid default judgments against absentee foreign corporations. Section 145 creates an inescapable jurisdictional loop. A foreign corporation can never weaponize the absence of local personnel to evade the reach of Philippine courts. Once operating locally, the foreign entity falls under the parity doctrine in Section 146. It is bound by the exact same rules and regulations as a domestic corporation. However, there is a strict boundary regarding internal affairs. The SEC governs how the entity operates within the Philippines, but it cannot dictate the laws of its creation, organization, or internal governance. If registered in Delaware, the Philippine SEC has the power to revoke its local license, but possesses no legal authority to mandate the dissolution or death of the Delaware entity itself. While the SEC respects the foreign charter, any changes to corporate DNA must be mirrored locally. If the Home Office amends its articles of incorporation or bylaws, it has exactly 60 days to file authenticated copies of those amendments with the SEC. filing an amendment does not automatically expand the corporation's authority. Section 148 draws a sharp distinction between updating corporate records and pursuing additional business purposes. If the home country authorizes the entity to expand from software sales into automotive manufacturing, that foreign approval grants no rights in Manila. To engage locally, secure an amended license. A foreign corporation's local power is strictly quarantined to the specific purposes explicitly written within the four corners of its Philippine license. This strict tracking extends to international consolidation. Under Section 149, the SEC monitors corporate continuity when a foreign corporation merges abroad. The general rule requires that within 60 days of the merger taking effect abroad, the foreign corporation must file authenticated copies of the merger articles with the SEC. A critical exception occurs if the Philippine licensed entity is the one absorbed by the merger. Because its distinct legal personality ceases to exist, it must simultaneously file a petition to withdraw its local license. So what happens if a foreign corporation bypasses this entire regulatory structure and transacts business without a license? Section 150 delivers the ultimate penalty. It creates a profound paradox. The unlicensed foreign corporation loses its sword. It is completely barred from maintaining or intervening in any action in any Philippine court, yet the state leaves the shield intact for domestic citizens. The unlicensed entity can still be sued and held liable before Philippine tribunals on any cause. Keep in mind, this penalty targets entities actively doing business illegally. A foreign corporation making an isolated transaction retains its capacity to sue to enforce that contract. Philippine jurisprudence also applies the doctrine of estoppel as a defense. A domestic partner cannot knowingly contract with an unlicensed entity, accept the benefits, and then invoke Section 150 to escape their obligations. Section 150 is brilliantly asymmetrical. It weaponizes jurisdiction to disarm foreign hit-and-run operators, stripping their right to seek relief while leaving them totally exposed to local lawsuits. If a licensed foreign corporation violates the terms of its entry, the state can execute the entity's local presence. Under Section 151, license revocation is a purely administrative police power of the SEC, requiring no judicial intervention. While domestic corporations might be placed under delinquent status for certain oversights, foreign corporations face immediate revocation for severe violations, like failing to maintain a resident agent, transacting unauthorized business, or evading Philippine taxes. Section 152 perfects this administrative execution through the issuance of a formal certificate of revocation. Due process is satisfied efficiently. The SEC simply mails the notice and a copy of the certificate to the corporation's registered office in the Philippines, immediately terminating its authority to operate. But what if the foreign corporation decides to leave voluntarily? Section 153 prevents a quiet escape, requiring a formal petition for withdrawal. The absolute prerequisite for withdrawal is the complete settlement of all accrued claims and liabilities in the Philippines. Every domestic debt must drop to zero before the SEC releases the securities deposited back in Section 143. A foreign board of directors cannot simply vote to abandon their Philippine operations. They must navigate this highly regulated clearance process to unlock their captive funds and legally exit the jurisdiction. Title 15 acts as an exercise in jurisdictional engineering. It establishes a highly fortified legal perimeter designed to welcome foreign capital, while ensuring that Philippine law exclusively dictates the terms of engagement, accountability, and exit.